I'm Lori Cripp Martin, certified family law specialist. I'm also the vice chair of BHBA's litigation section. I'm delighted to introduce today's speakers, Adam Levitt, Diandra Debrosse, and Amy Keller. Adam Levitt is a partner at DiCello Levitt, LLP, and one of the nation's leading advocates for plaintiffs in complex class action and multi-district litigation. He has secured over $25 billion in client recoveries across a wide range of industries and played key roles in landmark biotechnology, environmental, and public client cases. Known for his innovative strategies and leadership, Adam has been entrusted with some of the most high-profile and impactful litigations in recent history. Diandra Debrosse is a partner at DiCello Levitt LLP and managing partner of the firm's Birmingham office, where she leads high-impact mass tort, civil rights, and product liability litigation. Nationally recognized for her advocacy on behalf of individuals and public entities, Fu has recovered nearly $1 billion for clients harmed by corporate misconduct, discrimination, and defective products. She holds key leadership roles in major multi-district litigation, including actions against infant formula, hair relaxer, herbicide, and social media companies. Our third panelist today is Amy Keller, who's the managing director of the firm's Chicago office and the privacy, technology, and cybersecurity practice chair. Amy has held leadership positions in a variety of complex litigations across the nation, where she successfully litigated high-profile and costly data security and consumer privacy cases. Amy has represented consumers against industry titans such as Apple, Marriott, and BMW, securing victories against each. She has been appointed to the leadership positions in more multi-district litigations than any other woman in the last 8 years, with each case requiring sophistication in not only understanding complex legal theories, but also in presenting multifaceted strategies and damage modeling to ensure favorable results for her clients. And now let's get started.
Thanks very much, everybody. This is Adam Levitt. And as I say to people each time I speak in front of them for the very first time, I occasionally stutter when I speak. It's not a problem for me. It shouldn't be for you. If anything I say isn't 100% clear, please let me know and I'll go right back over it. Our partner, Debrosse, is running a little bit late. We apologize for that. She's actually in a hair relaxer deposition prep session that's running a little bit long, and she'll be on as, oh, she's on now. Look at that. And Fu is evidently on. But anyway, before anything, most important thing with all of this is that we hope that you and your family members in Los Angeles are safe in these incredibly trying times. And we hope that everything works out there, because obviously what's happening there is pretty much unprecedented in our history. We're not living through it, but you all are. So we hope everyone's okay. So as was said in the introduction, before we get into some of the other issues, is that our firm, DiCello Levitt, is an 85 lawyer firm in 8 cities around the United States. We also have affiliated offices in the EU, the United Kingdom, and in South America. We do a wide range of complex issues and trial work. And as a result of that, a lot of the things that we're going to be talking about this morning are things that we're dealing with, and I'm sure you're dealing with every day. But let me turn it over real quick to both Amy and Fu before we get started with the actual substance.
Thank you, Adam. I'll go next, just in alphabetical order. My name is Amy Keller, and I'm pleased to join you all today. Adam and Fu asked me to join based upon some of the issues that I've been encountering a lot in my cases lately related to discovery and certain discovery disputes we've had at the corporate level, especially as I litigate against a bunch of technology companies and the struggles that we face related to not only where the information can be found with technology companies, but also the asymmetry of information between plaintiffs and defendants in discovery disputes. So I look forward to having a robust discussion with all of you today.
Hi, my name's Diandra Debrosse, and I'm Adam and Amy's partner, and I am co-chair of the Mass Tort Practice, and I work on public entity work as well. I think that, discovery makes us all want to scream, and that's the truth of it, and it's frustrating. And I think sometimes, definitely when we were younger lawyers, it felt kind of pointless. Of course, as we developed cases and try to prosecute cases on behalf of our clients, we realize that it's not procedure, right? It's substantive. And if we can't get to what the defendants have, we really can't represent our clients. And I think we've all seen in our career a real negative trend towards just fighting us at every stage, I believe, affirmatively ignoring the rules of civil procedure on the federal level, on the state level, gamesmanship, not responding to discovery. And that has real ramifications for our ability to prosecute the cases. And I think it just has real ramifications in terms of the integrity of our justice system across the board. So it's a topic we're very passionate about individually and as a firm, and that we publish about extensively, and that I complain about at least on a daily basis.
Great. Thank you, Fu. And also, a lot of the things that we're talking about this morning relate to, or they arise out of, 3 columns that I wrote. I have a monthly column in the National Law Journal called Arguing Class Actions. And so it's 3 of them that came out last fall and a couple of them this spring relating to some of the experiences we've had. But if we can go to slide 3, I would ask Fu to kick off about the purposes and principles of discovery.
Sure. I mean, when we, obviously all of us on the plaintiff side anyway, advance the case and prepare our complaint, we have a good faith basis to make those allegations. And in theory, we have a good faith basis for the factual underpinnings. But the role of discovery is to find the truth. I mean, that's why the rule is a bit liberal. It can lead to admissible evidence. It's related to your claims. And the reason it's a liberal discovery is often the person from whom we're seeking justice has access to a lot of the information and the documents and the history that we need to establish that something bad happened in the past. And, how I often explain it to our younger lawyers is, we have a bizarre job. All of us, plaintiff side, defense side, have to reconstruct the past, what happened. And often for individual plaintiffs, they are not privy to all of the documents and policies and procedures and personnel and people who were ultimately involved in whatever terrible things occurred to them. And that's the purpose. We're looking for facts, and we're trying to understand what happened in the past. And we're also trying to balance the burden on plaintiffs who don't have access to information, while also balancing the burden, which is often overstated, on behalf of entities that have that information.
Yes, and I think also along those lines, as we said in the PowerPoint slide, the Seattle Times case, the US Supreme Court said very clearly, the sole purpose of discovery is to assist in the preparation and trial or the settlement of litigated disputes. Now, obviously, and some of the things we'll be talking about over the next 45 minutes or so, relate to the fact that what's been happening and what you all experience, what we all experience day to day, seems to move very far afield from that very simple function and purpose. So I think it's important, though, that in terms of, and Fu, if you wanted to talk about the importance of early preparation as well, so that we know what the rules of the game are, I think that would be helpful.
Sure. And I think for Adam, Amy, and I, and our other partner Brian, who couldn't be on today, especially I think whether you practice in one jurisdiction or not, an understanding of standing orders in that courthouse. You might have a complex or consolidated case that has multiple standing orders by the time you entered the case. And especially for us across different jurisdictions, it's necessary for us to understand what are the local rules vis-a-vis discovery? What are the standing orders? Something that we often do as well is, pull the orders of that judge in other cases. Discovery is funny. Judges have a lot of latitude in terms of what they find to be a problem, what they don't, whether or not they appoint a discovery special master, what are their preferences, what have they ruled on regarding, paper documents. I always find that to be a real fight. A company's been around 100 years. What happened to those paper documents? How do you get to them? Will the court require that you review them on site? So I think there are often a lot of questions that we can answer by doing a little due diligence on the front end and finding out, how has this judge or magistrate ruled previously. And often, I think if you're pairing with other lawyers who practice more in the jurisdiction, spending time speaking to other lawyers and understanding how the discovery process went in their particular case. Amy, do you have some thoughts?
Absolutely. Of course, all this is balanced against some of the newer arguments that we're seeing more and more as part of this meet and confer process. Something that is new to Federal Rule of Civil Procedure 26B1 is this concept of proportionality. Now, proportionality has always been part of the Federal Rules of Civil Procedure, but now it is an argument that we see more and more as a way to restrict discovery on the other side. And some of the things that you have to think about when you're seeking information are the importance of the issues at stake in the action, the amount of controversy, the parties' relative access to information. This is what we're calling the asymmetry of information, the resources of the parties, the importance of the discovery to what you are trying to resolve and the issues in your litigation, and the burden of or expense of the proposed discovery. So as you're preparing and you're reading the rules and the standing orders and you're understanding all the deadlines, you should also have in mind what are the arguments going to be against getting the fulsome discovery that you need to prove your case. If you're on the plaintiff side, and then of course on the defense side, thinking about, what are the arguments related to proportionality, what are the limitations that can be in place as you're moving forward. This is something that comes up again and again and again in litigation, talking about what does proportionality mean and what are the limitations of it. So far, what we've seen is that proportionality, nothing has really changed so much in terms of the rulings that come down related to what is and is not appropriate to discovery and what is and is not too expansive. But instead, it's more front-loading the issue so that it's reserved, so that it's resolved at the outset when you have these discovery requests and when you have these 30B6 deposition topics. The parties dig into these issues much sooner than they would have before.
Thank you. Let's go to the next slide. So I think one of the things that we've all seen and we've all experienced, and obviously we understand that our audience here is not all people on our side of the fence. So for those of you on the defense side here, feel free to consider this an admonition of sorts. But anyway, this is all arising out of the experience that we've had. And I think that a lot of the corporate evasion tactics in discovery really fall into a series of clear patterns. And Fu, if you want to speak to extending the first day order negotiations, I think that would be helpful.
Sure. So I think in a lot of our cases, obviously dependent on the nature of the cases, there are protective orders that have to be negotiated and put in place. Often there may be early discussions about ESI and a number of first day orders that help organize the litigation, assist the judge, and help us get off to a great start to the extent you could get off to a great start when you're litigating. And what we see more and more is rather than conceding common issues, whether it's giving plaintiffs and their experts access to a site for initial inspections, it becomes, as Amy said earlier, a meet and confer morass. There are 10 emails and letters about a meeting to have a meeting to talk about the ninth draft of the first day order, rather than just really acting in the spirit of getting some protective orders and necessary pleadings and orders in place so we could move forward with the litigation. And so in our mind, a lot of those types of orders could be negotiated in 60 days, sometimes 30 days, and instead they could just drag on for months. I think we would like to believe it's not intentional, but in that it has become a pattern and used as a tool of negotiation, it seems to have become a way to slow down the process. And often, I mean, to be fair, I think it lays in the judge's hands often as well to say, I have no idea why you all are taking so long to enter a protective order, what kind of gamesmanship is going on. But sometimes you don't have a court that's focused on that. I mean, judges have hundreds of cases. And so we have found in our practice that it's something that could just drag on for months when that's really not necessary.
Amy, do you have any views on that?
Yeah, I would definitely recommend from the outset for both sides of the aisle to maybe work with the judge and see if you can get hard and fast deadlines in place to either propose competing provisions of your protocols and draft orders or the orders themselves. One of the things that has significantly helped me and opposing counsel as well whenever we are negotiating these orders is asking the judges, hey, can you help us set some deadlines here? And they are hard deadlines. And it helps the parties cut through some of the mean confirm morass that my colleague Fu was referring to, where you're kind of exchanging a draft of a draft and your final positions aren't really there, and you still have a lot of leeway for negotiation, but you're kind of starting from, your furthest point away from the middle. Sometimes having these hard and fast deadlines in place, you cut to the issues that are actually very important right away. And sometimes just presenting these issues to the judge, your competing provisions in those orders, and really what you're wanting and trying to get at cuts through some of this stuff at the end of the day. So having finding a judge that is friendly enough to help you work through those issues is great. And then once you have an order in place that has worked in prior litigation, helping to get to, the meat of all of the issues, sometimes proposing that order again and citing to the previous case where it worked is a really great way to present the issue to the judge.
No, absolutely. And I think we could all say this on both sides of the fence, hopefully, that getting this stuff squared away quickly is vitally important. I think one of the things, and I was actually speaking on this in court about 3 weeks ago, we were in the midst of a hearing where the other side said all the plaintiffs want to do is engage in a fishing expedition. The bottom line is that we're on a contingent fee. The last thing we want to do is waste our time. We want to get to the point, get the information we need, work it up, and go to trial if we can. And that's really what this is about. We aren't interested in wasting time. We're not interested in going down non-fruitful paths or rabbit holes. And it's one of those things that we're dealing with every day. So the second point on this PowerPoint slide relates to improper privilege assertions. And what we've been experiencing more and more over the years is lots of over designations on privilege logs. And so much so it's been written about from the Google ruling in 2024, Judge Sabra in San Francisco issued a very pointed ruling, which I talk about at some length in my April 7th, 2025 column entitled "That's Not How Any of This Works." But I think the key thing on a lot of this, it's a combination of over designation on the one hand, while on the other hand, also the deletion or withholding of relevant documents. And there was an article earlier this year where the former chief operating officer of Meta, Sheryl Sandberg, was sanctioned in an investor lawsuit for getting rid of emails. And that's a real problem. But I guess the key point is that a lot of this, and we'll talk more about this in the ensuing slides, is that a lot of corporate defendants and their counsel engage in discovery evasion as a litigation tool and as a cost of doing business. And that's just one of those things where I think, and again, we'll talk about what to do in terms of expanding sanctions, as we suggest down the road a few slides from now, as to why we have to shift this paradigm from simply saying, this is all okay, or sanctioning someone in a certain way relating to their conduct in this case, and getting out of the idea that this is a proper way of doing things. If you want to speak to the AI copyright case, I think it would be helpful, Amy, in terms of the 18,000 documents.
Sure, yes, I'm happy to do so. So one of the things, that we've seen more and more in some of our litigation against large technology companies is just sort of the delay in the production of those documents. In addition to the improper assertion of privilege, right? We finally, when we get past the privilege dispute, or we have sort of an in-camera review of certain documents to see if there is an overbreadth of privilege assertions, then it comes time for a rolling production of documents. And a rolling production of documents, while it sounds great in practice, sometimes results in the documents coming very slowly, in a very, disorganized fashion, seemingly unconnected to the order in which you've negotiated your search terms. And so some of the things that we've been dealing with are these delays in productions. And then finally, when the productions are given to us, they're incomplete. We see situations where we may have a parent document, but we don't have the children documents or the related documents or the attachments, which can sometimes lead to a whole new privilege dispute about, okay, well, the email itself wasn't privileged, but somehow the attachment is, which can be incredibly frustrating. One of the things that we've been having to do more and more lately is follow up every single meet and confer discussion with a letter that has, the topic points that were discussed, the decision points that we came to, which side is doing what in terms of follow-up, and what the plaintiffs or the defendants have said their next steps will be, just to document everything, which in of itself is a very good practice, because inevitably, you're going to need some guidance from the court to help you get to a resolution on some of these issues. And so when you have incomplete productions, when you have delayed productions, the moral of the story is do not wait till the end of discovery to get assistance from the court or the special master or the magistrate judge. Instead, what you should be doing is making moves continuously toward the end of discovery, and also making sure you alert the court sooner rather than later. Now, we've discussed this before. Sometimes it gets a little tricky because you have these seemingly endless meet and confers. Well, there is that you need to decide, okay, we've had enough meet and confers. We're going to the court now. We've engaged in a rolling production of discovery, but 2 documents per week isn't going to cut it. I'm going to the court for assistance now. And when you have, intermediate deadlines, like say, for example, you have a deposition coming up of someone or a 30B6, if you don't have the entire production, there's no way you can adequately prepare to actually take that deposition, right? So you have to inform the court frequently throughout the discovery process how you're doing. You have to go to the court on a motion to compel if things are moving slowly. And another thing that happens that you should consider doing is scheduling regular check-ins with the court or the magistrate judge or the special master to inform them how the discovery process is rolling along. Because the last thing they want to hear is when you're getting toward the end of discovery, the plaintiff's now complaining, we don't have a fulsome production. Same thing for the defendants, complaining, we don't have a fulsome production. Well, discovery is going to end in a week. Why didn't you tell me sooner? So continuously inform the court, make sure you have those touch points, and move to compel if the meet and confer process is not resulting in any significant change from the other side.
And I think even if, I think one of the challenges, and I was going to say something about the extending first day order negotiations in the context of all of this, I will use the legal term bad behavior, is we all risk, very much upsetting the judge. And what I've come to realize is an upset judge helps no one. If you begin with the judge saying, I can't believe you guys have been messing around for months about first day orders, or I'm looking at an insane privilege log and I'm going to, in camera get you guys, I'm going to take a sample and this is ridiculous. There's nothing privileged about this document. I've found that we may like to hee when one of us gets in trouble, but I found more than not that the courts get very irritated with both sides if we just become mired in what should be just moving forward. That's the purpose of the rules, is to help us get through the process. And I think that both sides end up compromised when you have a judge who, quite frankly, becomes sick of you. And I think we've all been subject to that. I think also to the extent that the privilege assertions which are often totally overbroad, underinformed in the sense that I've had defense counsel say, well, there's a lawyer on the email. That in and of itself does not make it privileged unless that lawyer is representing you and providing advice in that capacity. And there are occasions where there's a fraud allegation. If there's an allegation that lawyers engaged in wrongful conduct, then there's arguments that it is not privileged. So there are a lot of contours to privilege, and I say that to the extent that it's not intentional. Oftentimes, in the midst of these very large litigations, folks have doc reviewers and young associates, and they're sitting there in their pajamas at home, scrolling through Everlaw and clicking privilege. And then you've got a problem. You have a privilege log that I've seen some that are quite silly. And so I think there's an obligation, to have a seasoned lawyer who understands privilege, which is quite complex, to make sure that A, you're providing a privilege log, because sometimes we have to fight over the provision of a privilege log, and that it is truly a privilege log, because we have our own teammates who are gifted at challenging privilege, and that becomes another sequence of months engaged solely in privilege litigation and argument and in front of a special master or the judge, and it costs everyone time. It costs that company time and money, and often on our side, because I do a lot of health and life work, we have our clients who die while we are playing around in discovery for 2-3 years when it's not necessary. And I think with regard to deletion or withholding of relevant documents, to the extent that it's not intentional, I think part of the problem is the discipline and rigor with which defendants issue litigation hold letters and speak. I'm going to say something unpopular. Talk to your employees. We're in the world of emails and letters, and you send some obscure litigation letter out in email form to, 15, 20 chairs of your departments. they probably haven't seen it or paid attention to it. If you are facing major litigation, you need to call them. You need to have a meeting. You need to talk to your IT and say stop purge protocols. You need to ask yourself internally whether or not your folks use their cell phone for work. You need to actually think through who has the documents, because I know my partners and myself and our firm, we're going down there. We're going to ask that CEO and your staff and the 30B6 deponent, what about this? Where is this? What did you do to preserve this? Why didn't you preserve it? Why? I mean, we will go there. And I think if you get the wrong judge, it can be very public and you could be facing sanctions. Now, under a lot of rules, we can't receive copies of those litigation hold letters unless we have reason to believe at that point that you are in violation, that you did not preserve. But there are different rules in different states, and that's not everywhere. So I think it just, advice for the defense bar, just, actually talk to your client and figure out, where is this stuff? We've all been there, and we're all normal people who happen to be lawyers, and you're fighting with defense counsel. No, I think you have paper. Your client's been around for 80 years, and you're just fighting to fight. And then you end up in front of a judge, and the judge yells, "Do you have paper or not?" And then that lawyer's like, "Okay, let me go back and speak with my client." So I guess my legal advice is, let's just be people. If you spoke to your client 6 months before, knew you had paper, had the discussion with us, that would save everybody a lot of time and a lot of heartache and help the litigation move forward.
Thank you, Fu. Can we go to the next slide, please? And deposition mayhem. Fu, if you can lead off on that one, then I believe you have a conflict and you're going to need to finish up your deposition prep. But if you can simply speak to this in the first instance, I'd appreciate it.
Sure. So I think, and again, I'm going to stay on the side of it's not intentional, although sometimes I know it is. But we do, on the plaintiff side, spend a lot of time determining the topics for 30B6 testimony. And we often serve with it subpoena duces tecum to make sure if you have not produced those documents, that document comes with the witness. And as you all know, and you all do, there will be different types of 30B6. And I'm going to ask Adam and Amy their percentage, but I would say more than 50% of the time, I walk that 30B6 deponent through the 30B6 deposition notice, and sometimes they haven't seen it, and they definitely are not prepared to testify to all of it, and they have not done what they're supposed to do under the rules, which is, if it's not in their personal knowledge, to take due diligence to find the answers to those questions prior to sitting for deposition. So A, colossal waste of time. B, violation of the rule. C, causes chaos in that deposition. Because now I'm peeved, defense counsel is peeved. You're asking depends on the defense lawyer. You're asking, did you prepare for this? No. Did you prepare for this? No. And to build a record, sometimes we just have to ask them the questions that they already testified in the first 25 minutes when we went through the deposition notice that they don't know. So we could build a record that you all were not prepared and take it to the judge. And I guess my common sense says, why are we doing this? Why are we doing this? And then it's a fight about keeping the deposition open and whether or not the person provided the documents. And so it's really a significant issue, because those are representations on behalf of the corporation, and we are entitled to that under the rule, and defense counsel is required to prepare that person to the extent that they can. So I think it's a huge issue. I think it's common for 30B6 deponents to appear and not be prepared. And I'll tell you, I think we've just all gotten used to people not following the rules, and that's not okay. There's a reason we have 30B6 depositions.
Yeah, and one of the things in terms of following the rules too, the amendments to Rule 30B6 in December of 2020 now injects this mandatory meet and confer requirement about the topics, right? And one frustrating thing from my angle is that we'll send Rule 30B6 notice with topics. set the deposition date, set the deposition time. The other side will say who the deponent will be, and we'll say, great. When should we meet and confer about the topics? And I'll follow up continually. When should we meet and confer? When should we meet and confer? Until it's, 2 days before the deposition. And we'll just get an objection to all of the 30B6 topics. And then what? So, if we're having a discussion amongst mixed company, I know that whenever I've been in a 30B6 deposition and I've called up the magistrate judge and I said, either we instruct the witness to answer the questions related to this topic or we hold the deposition open, the magistrate judge is going to let me hold it open so that you can prepare the witness to testify about this topic because you waited till the 11th hour to object to the topics, and I've been the one asking to meet and confer, throughout this entire process. So, if the other side, if defendants have an issue with the topics and plaintiffs are asking to meet and confer, then the defendants also have to, in good faith meet and confer rather than holding objections until the night before, like things used to be done. And then, debating whether or not the topics are proper later on. This whole thing was meant to, get around the process of having these disputes during the deposition and having topics that are, supposedly overbroad. I can tell you that Fu, Adam, and I, along with what Adam said previously, we don't have time to engage in a fishing expedition, so we don't like overbroad topics. We're trying to get to the heart of the matter. But, to the extent there is an argument that they are overbroad, actually engage in the meet and confer process rather than holding the objections to the night before, because it's just a giant waste of client time.
Absolutely. So thank you. Can we go to the next slide, please? Slide 6.
I think this one, deposition mayhem. Do you mean the next topic?
Oh no, if you want to stay there, let's go back one. I'm sorry, Phil.
Well, no, that's not. I mean, I would put speaking objections and coaching along with witness non-responsiveness. And I think witness non-responsiveness can be a tricky phrase in that sometimes on our side, our clients are testifying or witnesses are testifying, but the examiner does not like the responses. So I want to be clear that that is not what I am speaking about, where a deponent is answering to the best of their ability and the best of their knowledge in the weirdness that is being subject to a deposition. I mean, that's not normally how we speak to one another. I'm speaking about the I don't know. I don't know. I don't know. That's category number one. That's ridiculous. Even though it's things that they clearly know or things that they provided with a verified response in response to the interrogatories or things that are just like common sense, like what's your address or what do you think about this? So that's the first one. The second bucket of non-responsiveness, and we have been subject to this more and more as I get older, are where no matter what question you ask the deponent, they go to a script. They go to the exact same 3 or 4 sentences, and they actually do not respond to the question, or they do not speak to the document. And why I'm speaking about speaking objections and coaching is because often that is paired with and it's different in all jurisdictions, whether or not you just object to form, whether or not you have speaking objections. Often there's a deposition protocol in place, but that non-responsiveness is just wrong. You're supposed to prepare your witness, of course, or your client, but under the rules, you are not to instruct them to not respond or to repeat the same themes or same words over and over again. And it's going to make me sound like a Girl Scout, but we are also officers of the court. And encouraging your client to lie, to misrepresent, to refuse to answer the question, I believe is very contrary to an oath a lot of us took a long time ago. So I have a real beef with the non-responsiveness. And I would also say, to the defense bar, we use it well. We cut those clips for trial 55 times. I don't know. I don't know. I don't know. And the witness has 3 degrees from Harvard and 2 from MIT, and they've worked in the field for 50 years. That's no bueno. Doesn't help anybody. doesn't look good for your client, doesn't get the answers we need. And again, it's something that I believe we've all gotten used to that is not appropriate, is not helpful, and it leads to a real fight in the deposition, during the deposition, calling the judge, keeping the deposition open, and just subjects your witnesses to plaintiff lawyers who will keep fighting until they get that response, or will use that testimony to their advantage in continuing to prosecute the case.
Makes
So
sense.
that's my soapbox on it.
Okay, let's go to slide 6, please. And I think we've been talking about a lot of this as part of the points we've been making in the earlier slides, but I think that there are very clear ways to stop this or to try to stop this. I mean, we have an internal rule at the firm that on a discovery response, a meet and confer letter has to go out in 48 hours. A meet and confer has to happen within that week. And we're going to get to court as fast as we reasonably can, because one of the points I know we keep on coming back to, wasting time is not something we're interested in. So I think that, as we were talking about earlier, early and aggressive record building is really important. As Amy, I believe, was pointing out, keep going back, keep on clarifying that this is something, there is no moral equivalence here, that we are trying to get meaningful and compliant discovery responses, and we aren't getting them. And I think that is vitally important. And I think the same way, as I was saying, we think it's very important to get in front of the court as quickly as reasonably possible. Obviously, one of the last things any judge, or frankly any magistrate even, hates is lawyers who are fighting on discovery. And I think that the fact that, or if we're able to spin it as a necessary evil, we got to get this done, we need clarity. I think that as we move our cases closer to trial, getting that clarity and sort of having all of the other noise fall away, I think is vitally important. Fu, Amy, what do you think?
Sure, and I think, and I'm sorry, I'll have to jump off after this, and I apologize to everyone. But lawyering calls, sorry, but I also think on our side, and it's not a judgment on lawyers, because especially on the plaintiff side, we balance so many clients and so many obligations, this is going to sound silly. You have to look at the discovery. Was the discovery due? Did they respond? And I think that is the number one threshold issue in terms of combating evasion and ensuring that defendants respond. We're all slammed. Have you sat down and read your interrogatories and read the answers? Have they responded? I think part of a pretty consistent and newer last decade violation of the rule is simply not answering, just putting in 3-4 paragraphs of objection. That's not proper. You're only not to respond if it's privilege. Otherwise, you preserve all your objections, you respond, and then we duke it out. And I think sometimes, the plaintiff bar, just being inundated with clients, may not look at all of those interrogatory responses or documents in response to requests for production until maybe like 30 days before a deposition or close to the discovery deadline. And they realize, holy cow, there really aren't responses or production, or to Amy's point earlier, there are massive gaps in production, or metadata shows information's missing. And so I think part of the strategy is to be disciplined and, have your litigation management software in a place where, you have that alert, defendants' responses are due. And then you have your own alert, it's time for me to review the responses, where you're timing it out so you have time to see what have they not produced, so you can get that. You could get in a fight over the items you need before, as Amy discussed, you just go take a deposition and you don't have all the information that you need. So I think as a threshold matter, it's really making sure that you're on top of your discovery and that you are making sure that all ROGs and RFPs and RFAs have been responded to in the complete manner in which you think it's appropriate, or you've fought for that and the judge has made a determination and you're at the end of the ability to force responses to your discovery request.
Thank you. I know we're getting a little short on time, and I know there's 3 specific topics we wanted to raise on the next 3 slides before taking any questions, but thank you, Fu. So let's go to the next one, slide 7, please. And this goes to the issue of the meet and confer abuses and using them as a defense strategy. As Amy pointed out earlier, the original intent of the meet and confer requirement that went into effect in 2006 was to really streamline and clarify any discovery disputes. Now it's gone way past that. And I think that this has now become, unfortunately, another way for our opponents to run out the clock. It becomes, as Amy pointed out and Fu pointed out, another avenue to raise fights, throw out the anchors, saying things like, we'll take it back to our client, which it's one of those things, whenever you hear something like that, whenever I hear something like that, it's the same as when any of us have been sitting on an airplane and the pilot comes on and says, well, folks, and then whatever he says after the word folks is never something good. It's never, folks, we're going to be early. It's folks, we're circling over Omaha. So here, the exact same way, saying we'll take it back to our clients really falls into 3, as I pointed out in my November 4th, 2024 column, which actually specifically focuses on meet and confer abuses as litigation strategy. There's a 3-part dance, so to speak, on the slow walk. Lack of availability, lack of authority, and lack of impasse. And I think of the 3, and then I'll turn it over to you, Amy, I think that of those, the lack of impasse and keeping something open forever in an effort to stop getting in front of the court may be the most frustrating part of all. But if you want to speak to that, Amy?
Sure. And when you say, I think of it as a pilot saying, folks, I think of when I'm on a customer service phone call and the representative promises me that they'll escalate my request, which means that I'm never hearing back. But, one of the things when I have younger associates prepping for their first meet and confer, I often tell them, your job is not to convince the other side that you're right. And your job ultimately, at the end of the day, is not to get anything else. Because we've already, through all the letter writing campaigns that we've engaged in leading up to the meet and confer, we've already put out, our arguments. Your job at a meet and confer, a live meet and confer, is to get the parties to say, this is my final position. This is my position. This is what I'm comfortable going to the court with. The worst thing that could happen in a meet and confer, either side, is for the parties to say, you know what, yeah, we'll think on that. We'll bring it back to the client, because usually the client has already said what their position is. And if you're a good lawyer, which all of you attending this CLE are, you've already gamed out with your clients all of the things that might potentially happen on the meet and confer, and all of the authority that you have to negotiate what your position might be. So, whenever I hear we'll take it back to our client, I just know you've already talked about this with your client. And whenever I say, I'll go back to my team about this, and we'll think about if we're going to, give you the plaintiff's full social security number or something like that, even though we wouldn't. I know full well, like, I'm going to talk to my team, and the answer is no. So really the meet and confer, absent really crazy circumstances, you should come away from that call knowing what your positions are. Because if you don't, and you don't have full authority to actually have these discussions, you're just wasting everybody's time at the end of the day. So, what I instruct people to do is get the position of the other side, understand what it is. If the other side has to go back and talk to their client, put a very short timeline on it. I need an answer in 2 days. And either way, we're getting ready to move for what we need.
Yes, I agree with you, obviously. All right, let's move on because we are running out of time to slide 8, relating to sanctions and judicial responses. And as we began to talk about earlier, the current sanction regime is wildly insufficient, because, especially when you're dealing with a wealthy opponent like Facebook or Google or any of the automotive companies. Sticking them with $1 million sanction isn't going to actually change anything. And I think one of the issues that we talk about here with the case study of In-Ray Facebook Incorporated Consumer Privacy User Profile litigation, I think that we saw there the limits on discovery sanctions. I think one of the things that would be really important, as we talked about, is rather than a judge simply looking to a defendant's misconduct in the context of that single case that you have, I think it's vitally important for a judge to actually look and understand what a defendant's conduct is across other cases on these exact issues. And I think that if we're able to show that this type of recidivism has been happening as a matter of course, and the judge in our case fashions a sanction that's actually commensurate with a recidivist abuser rather than 1 or 2 times in the context of this one case, I think it really opens up the possibility of a much heavier hammer. If you want to speak to that, Amy.
Absolutely. And I completely agree that monetary sanctions aren't really a deterrent, especially when you talk about the amount of money on the line for some of these defendants related to these lawsuits. If you're talking about a lawsuit that's going to resolve at trial for over $1 billion, spending $1 million on sanctions to hide, some of the most egregious documents seems like a bargain at twice the price. One of the things I've been talking about with my colleagues, including some of the attorneys who worked on that case, you have a double-pronged approach. Adam already talked about, the defendant's conduct and a pattern or practice of this kind of conduct across cases. One of the things that the plaintiff's bar has been talking about is actually challenging the pro hoc vice applications of the attorneys who are involved in these things. It only takes, a couple of times of discovery, abuse, and misconduct before you start scratching your head and thinking, is this sort of a badge of honor? If you have a client that you're really willing to go to the mat for, and it looks like a close call, but you are thinking, well, it's a close call on these documents. My client really has some, good views on this kind of stuff. I'm going to read this order in a way that's barely appropriate, but still, allows me to keep my law license. If you're doing things like that over and over again, the plaintiff's bar very quickly is going to start opposing your pro hoc vice application, because that seems to be really the only way. From our perspective, in addition to challenging the defendant's conduct from other cases, to really call into question the behavior of some of these attorneys who are engaging in this process. Encouraging your client to always copy a lawyer on communications, even if it's not for legal advice, to shield it with privilege as some part of communicate with care program. When you start doing these things over and over and over again, it is completely improper. And it's something that we're going to start doing if we continue to see this practice happening.
Along those lines, let me just say the one thing that I've experienced across a number of cases, normally automotive cases. Very often, the large automotive manufacturers will hire, in addition to their primary litigation counsel, outside discovery counsel. And the problem with that, and I'm just going to say what it is, if your whole job and the fact and your whole possibility of getting hired on future cases is to hold the line in discovery in every case, that firm has the incentive to actually lie. That firm has the incentive to hide things. That firm has the incentive to be as obstructionist as possible, because after all, that's what they believe they were hired to actually do. So I think in a lot of ways, what brings a lot of this full circle is when the incentives for a defendant's outside counsel are so great to cheat in discovery and obstruct the entire process, that's really a fundamental flaw with what we have here that needs to be dealt with pretty harshly, I believe.
I agree.
Yes, thank you. So we would open it up for any questions. The last PowerPoint slide that we have of substance really isn't something that we should spend a lot of time on, but one thing that we've done, if you can go to number 9, please. One of the things that we've seen really in the social media MDL, which is pending right now in Northern California, Judge Gonzalez-Rogers has it. In that case, the defendants opened a new front that is based on either an intentional or general misapprehension of how state attorneys general offices work relative to the other agencies in the state. And as a firm that handles an awful lot of public entity work, seeing what was happening there showed what happened was the magistrate issued an order that the Article 3 judge ultimately adopted that effectively comprehended or misapprehended the relationship between the sovereign, the state attorney general, and the underlying agencies, in that what they missed was the underlying agencies are clients of the state attorney general's office. They are not simply within the possession, custody, or control of the state attorney general. So that's an issue we've been dealing with across the board. And it's one of those few situations where the red states and blue states really, they agreed on this one with various state AGs ultimately leaving that case. So I think what's going to happen there going on, if that's not stopped, and we're working with the various state AG offices and the FJC and others in an effort to clarify what this really means, because this type of misapprehension is highly problematic. So we would open it up to any questions if you'd like. Oh, here.
Okay, so it
Questions?
looks like we have
Okay.
one question from
Yes.
Michael here. Can judges use adverse inferences as a response to discovery abuse? Seems like the most important hammer, as increases the likelihood of a poor result at trial, making the willingness to get hit with sanctions not useful. What are your thoughts?
We firmly agree. Actually, on slide 8, I think that the idea of using adverse inferences or a default judgment or something else that would ultimately result in shaping the case as it gets closer to trial, I think is a very effective sanction that in most ways is far more effective as a deterrent than simply hitting a company for whatever, $500,000 $1 million or whatever it is. An adverse inference would be something really helpful, I think. Amy?
Yeah, absolutely. And I think, we actually engaged in sort of briefing related to an adverse inference in one of my cases. And one of the things that you have to help the court with is what would the discovery that has been lost or delayed or, protected under privilege, what didn't it prevent you from finding out? And so that, if it goes to some sort of legal issue that you were trying to get to, the adverse inference then would relate to that very specific legal issue. So the adverse inference is carefully tailored to the discovery that you're missing out on, essentially, which is a very clean way and a rifle shot, so to speak, at resolving the issue, and one which we've definitely employed before.
Any other questions? Okay, I guess that's it. Well, thank you very much, everybody. We appreciate you taking the time on a Monday morning to hear from us about these really important issues. And if you have any questions, we're obviously easily reachable. Our information's on the screen and in the materials. And we look forward to speaking with a number of you in the future. So thank you.
Thanks, everyone.
You may be eligible for CLE credit in your state. Visit bhba.org/podcasts for more information.